LG Autonomy. Supreme Court got it wrong completely. And now to the news in full. The distinguishing characteristic of a federation is the constitutional division of powers between the central government and the component states, whereas in a unitary system, all powers flow from the center. In a federation, powers are dispersed between the center and the state. It is a two-tier structure, federal and state, without one tier being subordinate to the other, but each deriving its power and exercising them within the confines of a written constitution. In federalism, you have devolution or decentralization, but in unitarianism, you have the concentration. According to Casey, where the federal principle is the method of dividing power so that general and regional governments are each within a sphere of coordinate and independent. In the words of Professor Ben Wambweze, federalism is an arrangement whereby the powers of government within a nation or country are divided between a national, country-wide government and a number of regionalized governments. Federalism, according to Dicey, is a political contrivance intended to reconcile national unity with the maintenance of the states' rights, in the words of Hamilton, one of the founding fathers of the American Constitution. A federal state is an association of states that forms a new one. Professor M.P. Jain shed more light to the question of federalism. According to a famous aphorism, federation connotes a legislative government, there being a division of power between the center and the states. None of the governments can step out of its assigned field. If it does so, the law passed by it becomes unconstitutional. Questions constantly arise whether a particular matter falls within the ambit of one or the other government. It is for the courts to decide such matter, for it is their function to see that no government exceeds its power. The British government never lived under the illusion that Nigeria, with such a vast territory and consisting of ethnic nationalities with disparate backgrounds, languages, and cultures, could cohabit successfully under a unitary system. It was thus that Sir Arthur Richard, the then governor of colonial Nigeria, broached implicitly the federal principle when he laid before the Legislative Council on March 5, 1945, to scheme for a new constitution. To create a political system which is itself a present advance and contains the living possibility of further orderly advance, a system within which the diverse elements may progress at varying speed, amicably and smoothly, towards a more closely integrated economic, social, and political unity without sacrificing the principles and ideals in their divergent way of lives. As a matter of fact, the North justifiably never really wanted to be part of Nigeria from the outset. Indeed, they were able to secure an assurance from Her Majesty's government that there would be no interference with their religion and the way of life. This is the reason why, in spite of the amalgamation of 1914, the region was administered separately from the other parts of the country by Frederick Lugard, the governor. This continued under Hugh Clifford, who succeeded Lugard in 1919, after the First World War, whereas the Legislative Council set up by Clifford, which replaced the Nigerian Council created by Lugard, legislated only for the southern provinces except on the issue of expenditure where the North was brought into view. The governor legislated for the North by proclamation. It was not until 1946 that the northern leaders agreed to sit with their southern counterparts in the newly inaugurated Central Legislative Council. Of course, Sir Donald Cameron and Bernard Bodilon, both Nigerian governors before the arrival of Richard, made strenuous efforts in persuading the northern leaders on the need to be part of the Central Legislative Council. The bewildering diversities of the nationalities that make up Nigeria made federalism inevitable. Sir John Macpherson became governor in April 1948 and pushed the country further on the path of federalism. The question was pointedly asked in the process of drafting a new constitution to replace the much criticized Richard's Constitution of 1946. Do we wish to see a fully centralized system with all legislative and executive powers concentrated at the center? Or do we wish to develop a federal system under which each different region of the country would exercise a measure of internal autonomy? That question, we recall, was only partly answered in favor of federalism in the Macpherson Constitution of 1951, which introduced elective principle across the 3 regions of the country. At its second annual conference in Benin City in December 1952, the Action Group AG passed a resolution fixing 1956 as the target date for the attainment of self-government for Nigeria. It was the young party stalwart Anthony Enahoro who, on behalf of the Action Group, tabled the motion in March 1953, requesting the House of Representatives to accept as a primary political objective the attainment of self-government for Nigeria in 1956. Of course, on behalf of the Northern People Congress (NPC), the Saldana of Sokoto, Ahmadu Bello, urged the House to substitute in 1956 with "as soon as practicable." To underscore the seriousness of the AG, its 4 ministers, Bode Thomas, Author Press, Ladoke Akintola, and Adesoji Adeyemi, chose to resign, decisioning the idea of collective responsibility proposed by the Central Councils of Ministers in order to participate in debating and voting for the historic motion. As it turned out, neither the original motion nor the amendment was debated. As Alhaji Ibrahim Imam of NPC moved a dilatory motion for adjournment of the debate, members of the AG and NCNC then staged a walkout. Crowd of people in Lagos booed and jeered at Northern delegation after they left the House of Representatives, whereupon the NPC stalwarts vowed never to return to the Central Parliament. It was evident that McPherson's Constitution of 1951 had broken down irretrievably. The crisis generated by the motion of self-government, which was supported by the Western and Eastern regions but rejected by the Northern regions, highlighted the inevitability of a full-fledged federalism in Nigeria. That crisis led to the 4-day Kano riots of May 1953. In the deadly riot, 36 Nigerians were killed, while about 250 sustained injuries. In the same May 1953, the House of Chiefs and House of Assembly for the Northern region jointly passed the 8-point program. This region shall have complete legislative and executive autonomy with respect to all matters except the following: defense, external affairs, customs, and West African Research Institution. 2. There shall be no central legislative body and no central executive or policy-making body for the whole of Nigeria. 3. There shall be a central agency for all regions which will be responsible for the matters mentioned in paragraph 1 and other matters delegated to it by a region. 4. The central agency shall be as a neutral place, preferably Lagos. 5. The composition and responsibility of the central agency shall be defined by the order in council establishing the constitutional arrangements. The agency shall be a non-political body. 6. The services of the railway, air service, post and telegraph, electricity, and coal mining shall be organized on an inter-regional basis and shall be administered by public corporations. These corporations shall be independent bodies covered by the statutes under which they are created. The board of the coal corporation shall be composed of experts with a minority representation of the regional governments. 7. All revenues shall be levied and collected by the regional government except customs revenue at the port of discharge by the central agency and paid to its treasury. The administration of the custom shall be so organized as to assure that goods concerned to the region are separately cleared and charged to duty. 8. Each region shall have a separate public service. As can be seen from the above, the Northern leaders called for a confederation of a customs union in Nigeria, proceeding in the Northern House of Assembly in Kaduna in May 1953. Underscore the above, our wishes would be that full autonomy be given to each region so as to make the center weak or loose. Okay, so they've allowed for this since a very, very long time. I journeyed this far in order to recall that the federal spirit and character of Nigeria did not emerge from the blue. Therefore, any purposive construction of the constitution in the Nigerian context should advance the cause of the federal principle and not constrict it. Regrettably, the 11 July 2024 judgment of the Supreme Court only advanced the cause of a unitary state, which is antithetical to the spirit and character of the Nigerian Federation. A strong center is dangerous in multi-ethnic, multicultural, and multi-religious society like Nigeria. My listeners, over to you. Leave your thoughts in the comment section. Don't forget to like, to share, and subscribe. Thank you for listening. See you some other time. Bye.